The morning Marcus Whitfield decided to file for divorce, he made himself a cup of coffee first. He stood at the kitchen counter of their 23rd floor apartment, watching the Atlanta skyline sharpen through floor-to-ceiling glass, steam curling from his mug in slow, unhurried ribbons. He had rehearsed his argument so many times over the past 3 months that it had taken on a rhythm like a favorite song. Smooth, certain, inevitable. She owns nothing in her name. That was the fact he kept returning to, the one that felt like a key turning in a lock. 3 years of marriage, 3 years of watching the world defer to Celeste Beaumont Whitfield, like she was the center of gravity in every room she entered, and on paper, on every deed, every filing, every institutional record he had spent weeks quietly pulling, her name was absent. Not a single asset, not one property, not one account. To Marcus, so that meant one thing. Everything she used, everything that sustained their life together, was fair game. He didn't hear Celeste behind him until she spoke. "There's a board call at 8, she said, moving to the refrigerator with the unhurried precision that characterized everything she did. She was already dressed, a deep burgundy blazer, natural hair pulled back cleanly, no jewelry except the small gold hoops she wore every day. "I'll be done by 10 if you wanted to do that gallery walk you mentioned." Marcus turned. He studied her the way he'd been studying her for months now, searching for cracks. "Sure," he said. "That works." She didn't look at him long. She poured a glass of water, took 2 measured sips, set the glass down exactly where she'd found it, and walked toward her home office with a folder already open in her hands. Marcus watched the door close behind her. She doesn't suspect a thing, he thought. He was wrong. Celeste Beaumont had grown up understanding that wealth was a verb, not a noun. Her grandmother, Dorothy Beaumont, had built the family's first real fortune not by accumulating things, but by structuring protection around everything she touched. Dorothy had grown up in Birmingham during times when black ownership was not just challenged, but routinely destroyed. Businesses burned, land stolen through legal manipulation, wealth transferred out of black hands through systems designed precisely for that purpose. She did not build the Beaumont family trust in the 1980s out of paranoia. She built it out of history. By the time Celeste was old enough to understand what the trust meant, she had already absorbed its philosophy the way children absorb language, not through instruction, but through immersion. "You don't own things," her grandmother had told her once, was sitting on the porch of the Buckhead house that technically belonged to a limited liability company. Things own themselves when you build them right. You just carry the responsibility of them. Celeste had taken that lesson into every corner of her adult life. At 37, she held a voting seat on the Beaumont Family Trust's Strategic Committee. She served as a non-managing member of 4 holding companies. She participated in the governance of a healthcare infrastructure subsidiary that had quietly expanded into 7 southern states. She was, by any meaningful measure, one of the most financially significant women in Atlanta's private sector. Nothing was in her name. Not the apartment, not the vehicles, not the art on the walls, not the accounts that funded their household. Every asset moved through governance structures that predated her by a decade and would outlast her regardless of what happened in her personal life. That was the design. That was the intention. And that, as Marcus had recently begun to understand, was what he planned to dismantle. They had met at a political fundraiser on a Wednesday night in late October, the kind of event where the food was excellent and the conversation was strategic. Marcus Whitfield had built his career in commercial real estate development, ground-up projects, mixed-use communities, the kind of work that required charisma and relentlessness in equal measure. He was good at both. At 39, he'd closed enough deals to build a reputation and enough of a network to stay warm when markets cooled. He noticed Celeste because she wasn't trying to be noticed. While most guests circulated, angling for introductions, she stood near the window in a conversation with a city councilwoman and a hospital administrator, listening more than she spoke. When she did speak, both women leaned in slightly. Marcus watched that lean. He understood what it meant. He'd found a way into her orbit before the evening ended, and within 10 minutes he understood he was in the presence of someone who would not be impressed by the things that usually impress people. "What do you actually enjoy?" he'd asked her at some point. When the small talk had exhausted itself, She'd considered the question seriously, which surprised him. Solving problems that look permanent, she said. What about you? Building things, he said. From nothing. She'd smiled at that, not warmly exactly, but with recognition. That's the hardest kind, she said. He fell for her in the way people fall for things they don't entirely understand, completely, and with the quiet assumption that understanding would come later. It didn't. To quite. The prenuptial agreement had been drafted 14 months before their wedding, initiated by Celeste's attorney as a matter of standard practice. Marcus had reviewed it with his own counsel, a family law specialist named Derek Okafor, who had walked him through every clause with careful thoroughness. The document was detailed and precise. Premarital assets, trust interests, entity holdings, all remain separate property. Marital property would consist of income earned jointly, in assets acquired together, and shared accounts. Marcus had signed on a clear Thursday afternoon without negotiation. At the time, the agreement had felt like paperwork. He was not marrying her for money. He had told her that, and in that moment, standing in Derek Okafor's conference room with the document between them, he had believed it entirely. The first 2 years of their marriage were, by most honest measures, good. Not perfect. Celeste carried her professional precision into private spaces in ways that sometimes felt airless, but genuinely good. They traveled. They argued productively. They built the kind of shared life that requires negotiation and compromise, and the willingness to be changed by another person. Marcus had always assumed that closeness would eventually translate into transparency, that the structures surrounding Celeste's wealth would, over time, open to include him, not legally, perhaps, but practically, that being her husband would mean being inside the architecture, not just adjacent to it. It never happened, and the longer it didn't happen, the more that absence began to feel like a message. The first shift was subtle enough that Marcus could not have named the exact moment it occurred. It happened somewhere in the territory of his 3rd year of marriage. In the season when his commercial development projects were hitting a slow patch and his income had contracted from comfortable to careful. Nothing catastrophic, but enough that the differential between his financial life and Celeste's became impossible to ignore. He started noticing things he'd accepted before, without question. The apartment deed was held by a company called Beaumont Residential Holdings, 2 LLC, a name he found in county property records on an idle Tuesday. The vehicles were leased through a fleet management company tied to the trust's administrative subsidiary. When he'd asked Celeste once, lightly, why she didn't simply own anything outright, she'd given him an answer that had unsettled him more than he'd admitted at the time. Ownership isn't the goal, she'd said. Continuity is. He'd let that sit, but it sat wrong. He began talking more regularly with his friend Devin Marsh, a developer whose first marriage had ended in a settlement that had, depending on who you asked, either rescued him or ruined him. Devin liked to speak in certainties about things he only partly understood. New York's got equitable distribution, but Georgia's not much different in practice, he'd said one evening. If assets were generated during the marriage, or if one party benefited significantly from structures they didn't own, there are arguments to be made. He'd shrugged with the authority of a man who had paid attorneys a great deal of money to have that argument made. It comes down to what can be proven. What can be proven? Marcus had turned that phrase over and over. He began keeping notes, not because he was certain of what he intended, but because certainty, he told himself, required preparation. Celeste noticed the change before she could name it. It wasn't any single thing. It was a texture shift, something in how Marcus asked questions, something in the particular quality of his attention when certain financial topics came up. He had always been curious about her family structures. Now the curiosity had an edge to it, a searching quality, like someone testing the walls of a room for hollow spaces. She didn't confront it. Confrontation, she had learned, was a form of warning, and she had no interest in warning Marcus Whitfield of anything. Instead, she began writing things down. The notebook was black leather, small enough to fit in the interior pocket of any blazer she owned. She'd carried blank notebooks for years, a habit from graduate school that had never left her. But this one she dated deliberately, wrote in precise shorthand, and stored in the locked lower drawer of her home office desk. October 4th. Marcus referenced Beaumont Healthcare expansion as our portfolio in conversation with Devin Marsh. Framing notable. She didn't editorialize. She didn't write about how the framing made her feel. She simply recorded what had happened, when it had happened, and who had been present. She had no evidence yet of specific intent. But she understood momentum, and momentum in her experience always left a trail. The first time Marcus entered her home office without permission, he was careful. And he had waited until Celeste was on a call with the trust compliance officer. A call she took in the building's private conference room 2 floors down. He had watched her leave, timed the elevator's descent, and then moved through the apartment with a deliberateness he didn't fully acknowledge as trespass. Her desk was organized with the same quiet logic that governed everything about her. Files were aligned to the edge of the surface. A stack of board summaries sat beneath a weighted paperweight. He photographed them with his phone, moving quickly, hands steady. Nothing he found listed her as an owner of anything. Every document referred to entities, governance committees, fiduciary structures. He felt something that registered as vindication. What he didn't understand was the language inside those documents. The clauses specifying independent trustees, the governance limitations on beneficiary authority, the compliance certifications that had been signed and countersigned and audited. He saw the absence of her name. He did not see what the absence was protecting. That evening, Celeste returned to her office and noticed 3 things. The slight misalignment of her paperweight, a file shifted half an inch from its usual position, and a login attempt on her desktop terminal registered at 2:43 in the afternoon. She sat down in her chair, opened her notebook, and wrote, October 4th, secondary. An office entry during absence. Documents accessed, digital access attempted, no confrontation, continue observation. She closed the notebook. Outside, Atlanta moved through its evening. Traffic, light rain, the distant sound of construction on Peachtree. Celeste sat in the quiet of her study and understood, with the kind of calm that comes not from indifference but from preparation, that the situation had entered a new phase. She had not been surprised. She had been waiting. The attorney Marcus chose was named Sandra Price, and her office occupied the top 2 floors of a midtown building with a view of Piedmont Park. She had made her name on high-asset divorces, the kind where the financial complexity required both legal expertise and something close to corporate forensics. She was rigorous, expensive, and she did not traffic in false comfort. When Marcus sat across from her for the first time, he led with the phrase he had been practicing. My wife technically owns nothing, he said, sliding a folder of property records across the table. But she controls hundreds of millions through trusts and holding companies. Everything we use, this apartment, the cars, the accounts that fund our lifestyle, it's all coming through those structures. Sandra reviewed the documents without rushing. Prenuptial agreement, she asked. Signed before the wedding. My own attorney reviewed it. Did you negotiate any terms? No. Well, I didn't think I needed to. Sandra looked up. Why are you here now? Marcus considered his answer carefully. Because I believe the structure is designed to look like nothing, and I want to know if nothing can be challenged. Sandra leaned back in her leather chair. Her expression was attentive but unreadable. In Georgia, she said, separate property established before marriage is generally protected. Trusts formed prior to the marriage, governed independently, again with no evidence of commingling, those are difficult to reclassify. She paused. However, if there's evidence the trust functioned as an alter ego, or if marital funds were commingled with trust assets, those arguments become available. Marcus felt the familiar surge of validation. She benefits from it every day. We live in property it holds. That has to mean something. Beneficial use, Sandra said carefully, is not ownership. She held his gaze. Hey, but it can be relevant depending on how it's framed. He left her office with a retainer signed and something he hadn't felt in months. Momentum. Celeste was already moving when Marcus filed, not because she knew the exact date, she didn't, not yet, but because the pattern had been completing itself with a clarity that required only patience to see. The office entry, the digital access attempt, the subtle reframing of her family's work as shared accomplishment in conversations with people who knew better. The evenings Marcus spent on his phone in the hallway, voice lowered, words clipped. She had, over the preceding weeks, done the following. Enabled multi-factor authentication on every account she managed. Archived 3 years of email correspondence into encrypted storage. I'd requested a routine internal compliance review from the trust's administrative officer. A review that was ordinary in every respect except its timing. Compiled a chronological file of every observation she'd made since October. When the formal divorce petition arrived by courier on a gray Tuesday morning, Celeste accepted the envelope, aligned it with the edge of the dining table, and finished the paragraph she'd been reading before she opened it. Her attorney, a corporate and family law specialist named Jonathan Hale, called her within the hour. "It's broad," he said. "They're requesting full trust documentation, entity records, distribution histories. They'll receive what the law requires," Celeste said. "Are there any commingling issues I should know about?" "No." "Any undisclosed transfers?" "No." "Any irregular governance?" "No." There was a brief silence on the line. "Then our strategy," Jonathan said, "is precision, full compliance. A no theater," Celeste agreed. She had never had any interest in theater. That night she opened her notebook to a fresh page and created a new section heading. Not divorce, not litigation. She titled it by behavior, the way she titled everything. Whitfield escalation. Documentation active. The record was now official. The process had a name, and Celeste Beaumont Whitfield, who owned nothing in her name and controlled everything through governance, was ready. And the discovery process began with deadlines, which is to say it began with consequences. Within 24 hours of the scheduling conference before Judge Harriet Cole, a family court judge known for her intolerance of procedural games and her commitment to clean evidentiary records, Jonathan Hale's office issued a formal preservation notice. Every electronic communication, every financial record, every device in Marcus Whitfield's possession was to be retained without alteration. With no deletion, no modification, no disposal of any kind. Marcus read the notice at his desk, irritation rising with each paragraph. He called Sandra Price. "They're treating me like I did something wrong," he said. "They're treating you like a litigant," she replied. "Which is what you are." He didn't like that framing. He never did. What Marcus had not considered, as he'd spent months reconstructing Celeste's financial architecture in his mind and building theories about trusts and alter egos and commingling, was that discovery moved in both directions. His bank records, his credit card statements, his investment accounts, his electronic communications. All of it was now subject to the same scrutiny he had hoped to direct at Celeste. The spotlight he had imagined illuminating her structures had a second beam, and it was aimed squarely at him. Because Celeste did not gloat when Jonathan presented the preliminary findings from Marcus's financial records. She listened, hands folded on the conference table, and asked 2 questions. What was the date range of the discrepancies, and had every document been preserved in original format? The discrepancies were significant. Not criminal. There was no fraud, no embezzlement, nothing that would reach that threshold. But in the context of a divorce proceeding, where Marcus had alleged concealment on her part, the inconsistencies in his own records carried weight. Hotel charges in cities unrelated to business meetings. Flights labeled client development that corresponded to no disclosed appointments. Wire transfers into a newly formed LLC, registered 3 months before the divorce filing, address listed as a co-working space, that had not appeared anywhere in his initial financial affidavit. Jonathan had laid it out without editorial. The entity was not disclosed. The transfers were not disclosed. The timing is difficult to explain in isolation. Celeste looked at the formation date of the LLC. She looked at the dates in her notebook. October, the same month as the office entry, the same month as the deleted emails. She wrote one line in the margin of her notes. Financial divergence aligned with litigation preparation. She did not write conclusions. She wrote alignment. So Marcus met Sandra Price in her office the following week, and for the first time, she was the one asking the hard questions. "These hotel charges," she said, sliding a printed statement across the desk. Saturday nights in Savannah. No corresponding conference listings. No client meeting records. Networking, Marcus said. I have contacts there. Sandra's expression remained neutral. And the LLC? An investment vehicle, IC for future development, formed 90 days before you filed for divorce. The timing was coincidental. Sandra looked at him for a long moment. In litigation, she said, coincidence is not a legal defense. It's a prompt for scrutiny. She closed the folder. I need you to understand something, Marcus. The strategy you came in here with, challenging Celeste's structures, arguing that beneficial use equals marital ownership, that strategy requires your own credibility to be intact. If opposing counsel can establish a pattern of financial irregularity on your side, it undermines every argument we make about hers. Marcus sat back. So what are you saying? I'm saying discipline matters now. Every communication, every transaction, every statement you make in a private conversation that could be overheard, recorded, or repeated. He stiffened at that last word. Recorded? Sandra met his gaze. These are high-asset proceedings. Parties document everything. I'd assume the same. What Marcus did not know, what he had no way of knowing, because the surveillance system had been installed by the building security firm years before he moved in, was that Celeste already had him on camera. The footage from the apartment's hallway cameras was time-stamped and unambiguous. Jonathan Hale reviewed it with Celeste in his private conference room, the two of them seated side by side in front of a laptop screen. The clip was 37 seconds long. It showed Marcus emerging from the hallway adjacent to Celeste's study on the afternoon of October 4th, phone pressed to his ear. The audio, captured by ambient microphones installed as part of the building's security protocol, was faint but clear enough. Yeah, I talked to Sandra this morning. If she technically owns nothing, that's the angle. We argue control equals ownership. On paper, she's empty. In reality, she's not. That gap is everything. A pause. No, she has no idea. I checked. Nothing's in her name. That's what we use. Another pause, shorter. I already cleaned up some emails. Just routine stuff. The room was quiet after Jonathan paused the clip. This establishes intent, he said carefully, both to exploit the structural absence of her name and to delete communications relevant to the proceeding. Prior to formal filing, but after he'd already consulted counsel. Celeste's hands rested still in her lap. What does the deletion window mean legally? If litigation was reasonably anticipated at the time of deletion, and consulting a divorce attorney almost certainly qualifies, then destroying responsive communications constitutes spoliation. It doesn't automatically result in sanctions, but it creates grounds for an adverse inference. The court can tell a jury to assume the deleted communications would have hurt his case. Celeste nodded slowly. In the recording itself? The property is held by Beaumont Residential Holdings. The surveillance policy predates the marriage and was disclosed in the lease agreement Marcus signed when he moved in. It's not a trap. It's documentation. Jonathan paused. I want to be precise about this. We're not presenting it to punish him. We're presenting it to establish sequence and intent in response to his commingling allegations. I know, Celeste said. Preserve it. We'll use it only if necessary. Jonathan studied her. Most clients would be considerably more animated about this, he said. Celeste almost smiled. Anger doesn't improve outcomes. The sanctions motion was filed on a Tuesday, 14 pages of precise legal language citing incomplete production, deleted communications, and a newly recovered audio evidence demonstrating that Marcus had formulated his litigation strategy with explicit awareness that his case depended on mischaracterizing a governance structure he fully understood to be separate property. Sandra Price called Marcus at 8:15 that morning. There is audio, she said without preamble. Audio of what? Of you, in the hallway outside Celeste's study, on October 4th. The silence that followed lasted 4 full seconds. That's private property, he said finally. His voice had changed register. It's property held by the Beaumont Trust, Sandra said evenly, with an established surveillance policy you agreed to when you moved in. She paused. Marcus, you told someone you'd already cleaned up emails. That was nothing. In litigation, nothing becomes something. Her tone was not unkind. It was precise. Do you understand what an adverse inference instruction means? He did not answer. In the sanctions hearing took place before Judge Harriet Cole on a Friday morning. Jonathan presented the timeline without theatrics. The consultation with Sandra Price in September, the office entry on October 4th, the email deletion log the same afternoon, the audio clip captured in the same hallway within 20 minutes of the deletion activity. He played the recording once. Marcus's voice filled the courtroom. On paper, she's empty. That's the angle. No one spoke for a moment after the clip ended. Judge Cole looked at Marcus directly. Mr. Whitfield, did you delete communications after consulting divorce counsel? Marcus swallowed. I cleaned my inbox. I didn't know litigation had formally begun. You had retained a divorce attorney. Yes, the judge made a note. Intent is assessed objectively. She issued a narrow but firm ruling, monetary sanctions for incomplete production. An adverse inference instruction to be considered at trial regarding any communications related to asset classification, and full forensic imaging of Marcus's devices under neutral supervision at his expense. Outside the courtroom, Sandra spoke to Marcus quietly, while Celeste and Jonathan walked ahead toward the elevator. This does not end the case, Sandra said, but it alters posture significantly. Marcus watched Celeste's back as she moved down the corridor, but she didn't look over her shoulder. She didn't need to. What the forensic imaging revealed was not explosive. It was sequential. The neutral examiner recovered partial email chains from Marcus's devices, threads that had been deleted before formal filing, but after his first consultation with Sandra Price. None of them contained anything criminal, but several contained exchanges with Devin Marsh that established, in Marcus's own words, a clear theory of exploitation. If she controls it without owning it, that's the argument. Control during marriage equals marital interest. Get Okafor to look at the alter ego doctrine. And separately, 2 days earlier, I've been pulling her property records. Nothing's in her name. That's actually better for me. Means everything she uses is arguable. He had understood the structure. He had read it clearly. And he had made the deliberate choice to frame that understanding as concealment when he filed. Jonathan did not dramatize the findings when he presented them to Celeste. She reviewed the recovered threads in a summary document, read each excerpt twice, and then set the paper on the table with the same quiet finality with which she closed her notebook every evening. He knew, she said. It was not a question. Yes, Jonathan said. He understood the trust was separate. He chose to argue otherwise. Celeste was quiet for a moment. Outside Jonathan's office window, Atlanta glittered in the cold December light. Does this change the classification hearing? It changes the credibility assessment, Jonathan said, which affects everything. She nodded. Then we proceed. The discovery phase had done what discovery phases do when one party has been meticulous and the other has been careless. It had reversed the pressure. Marcus had filed expecting to expose Celeste's structures. Instead, his own inconsistencies had accumulated into a pattern that the court found increasingly difficult to interpret charitably. The temporary support hearing had gone badly for him. Judge Cole had declined to award significant support, citing Marcus's intact earning capacity and the documented nature of Celeste's distributions as fiduciary income rather than personal salary. In the LLC formation proximate to filing had been flagged for supplemental explanation. The hotel receipts had required written justification. Each procedural step had required him to defend choices he'd thought were invisible. For Celeste, none of this produced satisfaction in the way people imagine satisfaction looks. She did not arrive at these developments flushed with vindication. She arrived at them the way she arrived at every board meeting, every governance vote, in every quarterly review, present, prepared, and unmoved by the noise. She continued attending trust committee meetings throughout the proceedings. She voted on 2 infrastructure investment proposals in November. She approved a philanthropic grant tied to a pediatric healthcare initiative her grandmother had funded 20 years earlier. And the litigation was not mentioned in any of these settings because legally, and her grandmother's lawyers had been meticulous about this, Celeste's personal circumstances were irrelevant to the trust's operations. The trust did not depend on her marriage. It had never depended on her marriage. That was the design. That had always been the design. One evening in late December, the Atlanta skyline lit up through the apartment windows. Marcus came home unexpectedly early and found Celeste at the dining table with a cup of tea and a stack of governance summaries. He stood in the doorway of the kitchen and looked at her for a long moment. "You turned everything against me," he said. His voice was tired rather than angry. "I haven't spoken publicly to anyone," she replied without looking up. "You don't have to. They all see it." "That's not something I did, Marcus." He moved closer, leaned against the counter. "Flora, you never thought this marriage was real, did you? It was always just another structure to maintain." She set down her pen and looked at him. The expression on her face was not cold. It was honest in a way that honest faces sometimes look unkind. "I thought this marriage was real," she said quietly. "I documented it because reality requires records." "That's not the same thing." He opened his mouth, closed it. "I documented it the same way I document everything I value," she added. "Tish, not because I was preparing against you, because I believe clarity is a form of respect." He didn't answer that. He went to his room and closed the door, and Celeste sat for a long time in the glow of the city before she picked up her pen again. December 19th, she wrote, "Conversation, kitchen." He is beginning to understand what he built. She didn't write what she meant by that. She didn't need to. Or the mediation suite was quiet in the way that rooms become quiet when the arguing is over and only the accounting remains. Judge Rhett Ellis, a retired appellate judge who had presided over more high-asset divorce mediations than he cared to count, had the unhurried manner of a man who understood that most cases arrived at his table already decided. The legal questions, at least, already answered by the documents. The dramatic performances had concluded in courtrooms. Here, in this carpeted, neutral-toned suite with water carafes and legal pads, and a view of downtown Atlanta from the 14th floor, what remained was math and acceptance. Marcus sat beside Sandra Price at a long conference table, his hands folded with a stillness that looked like composure but wasn't. Across the table sat Jonathan Hale with a thin binder and a yellow legal pad. Celeste sat beside him with her black notebook closed in front of her for the first time in months. Judge Ellis opened without ceremony. "Oh, I have reviewed the filings, the discovery record, the sanctions order, and the prenuptial agreement," he said. "Let me be candid about where we are." He looked at Sandra first. "You intend to challenge the prenuptial agreement." "We contend," Sandra said carefully, "that the scale of the trust's assets relative to the marital lifestyle and the degree to which Mr. Whitfield participated in business representation efforts benefiting trust entities warrants equitable consideration beyond what the agreement strictly provides." Judge Ellis turned to Jonathan. "Response?" "The agreement was negotiated with independent counsel 6 months before the wedding," Jonathan said. "Full financial disclosures were attached. Mr. Whitfield's attorney reviewed every clause. He signed without duress, without coercion, and without time pressure. The trust predates the marriage by 9 years. Its governance structure is independent, and there is no documented commingling of principle." He paused briefly before adding, "We further note that Mr. Whitfield's own communications, now part of the record, demonstrate full awareness of this separation prior to filing. The allegation of concealment was not a discovery. It was a strategy." The room absorbed that. Judge Ellis looked at Marcus directly. "Mr. Whitfield, when you signed the prenuptial agreement, did you have independent legal representation?" "Yes." "Did you read the document?" "Yes." "Do you allege that you were misled about the nature of the trust or its separation from marital property?" Marcus was quiet for a moment. "I understood what it said. I didn't fully understand what it meant." Judge Ellis nodded. "That is not coercion. That is regret." He set the agreement aside. "The prenuptial agreement will not be set aside on unconscionability grounds. The trust assets predate the marriage, are governed independently, and show no evidence of transformation into marital property." He looked at both attorneys. "What remains are the marital assets, joint accounts, shared investment gains, income earned during the marriage, and the question of attorney's fees in light of the sanctions order." Sandra made one last attempt. Your Honor, even accepting those parameters, we would argue that the disparity between Mr. Whitfield's marital contributions and the lifestyle that trust distributions enabled warrants some equitable recognition beyond strict classification. Judge Ellis regarded her. Participating in a lifestyle supported by a spouse's separate assets does not transform those assets. New York said it clearly. Georgia agrees. Mr. Whitfield held no formal position in any trust entity. He received no compensation from any trust subsidiary. And he has produced no documentation demonstrating managerial contribution to trust growth. He glanced at the folder before him. The disparity argument requires more than presence. The separate conversations that followed lasted 40 minutes. In Marcus's room, Sandra laid out the realistic parameters with the directness she was known for. Joint accounts split evenly. Your brokerage earnings from the marriage period divided per statute. One shared apartment improvements funded by marital income. Possible fee adjustments tied to sanctions? She slid the summary across to him. These numbers are not insignificant. They're also not what you came in here expecting. Marcus looked at the figures. He was quiet for a long time. She structured it perfectly, he said finally. Not with anger anymore. Something that sounded closer to acknowledgement. Sandra's voice was measured. Perfectly is not the legal standard. What she structured was compliant. The prenuptial agreement was clear. The trust formation dates were clear. The governance documentation was clear. She paused. You signed an agreement with full information. The court cannot rewrite that because the outcome is disappointing. In the adjacent room, Jonathan walked Celeste through the same numbers from the other side. Given the record and the sanctions order, you could reasonably push for maximum fee allocation, he said. And the position would be defensible. I won't, she said simply. He studied her. You've exercised restraint throughout this entire proceeding in ways that most clients wouldn't. Restraint isn't mercy, she said. It's strategy. Punitive demands generate appeals. They extend timelines. They invite scrutiny of posture. She looked at the figures. This ends cleanly. That matters more. Jonathan allowed himself a small smile. Your grandmother would agree. Celeste looked at him. My grandmother built something that survived decades of challenge, she said. This was nothing. When both parties reconvened, the agreement came together with the functional efficiency of documents that were already mostly written. Joint accounts divided evenly. Investment gains allocated by contribution percentage. Marcus retained his brokerage earnings. Celeste retained her trust interests in separate entity positions. Attorney's fees were adjusted modestly in her favor. She declined to pursue the maximum allocation. The signatures were collected without ceremony. Marcus held the pen longer than necessary. He thought briefly of the afternoon he'd signed the prenuptial agreement. That clear spring day in Derek Okafor's office. The feel of the conference table under his hands. The uncomplicated certainty that structure was unnecessary because he was not that kind of man. He had believed that then. He still wasn't sure when he'd stopped. Celeste signed without hesitation. Her handwriting was the same as always. Small, exact, consistent. Judge Ellis closed the folder. The matter is resolved. I'll file the recommendation with the court. He looked briefly at both parties before rising. I hope both of you find what you need going forward. Outside the mediation suite, the hallway felt wider than any hallway Marcus had walked in months. He lingered near the elevator bank while Jonathan and Celeste exchanged brief words near the stairwell door. When Jonathan stepped away to take a call, Marcus approached her. I thought I'd found something, he said, a real vulnerability. Celeste turned to face him. She did not appear relieved. She did not appear triumphant. She looked the way she had looked at every gallery opening, every charity gala, every board dinner he had accompanied her to over 3 years. Present. Contained. Clear? You found documentation, she said. He almost laughed. I thought nothing in your name was the whole story. Nothing in my name is the whole story, she said. Just not the chapter you were reading. A pause. My grandmother built what she built because she knew that names on paper are fragile, that systems outlast individuals, that the strongest protection isn't possession, it's architecture. She held his gaze. I didn't build it against you, Marcus. Ian and I maintained it the way it was maintained before I was born. The same way I'll maintain it after this." He was quiet. The elevator arrived. Neither of them moved immediately. "I underestimated you," he said. "You underestimated continuity," she replied. They rode down separately. The final hearing before Judge Harriet Cole lasted less than 20 minutes. The courtroom had a different quality that morning. Not tense, not charged, but concluded. Attorneys sat with organized binders. Clerks moved with the efficiency of people who knew exactly what was coming next. The gallery, which had been empty throughout the private proceedings, remained empty still. Neither party had spoken to the press. The confidentiality clause had been mutual and had been honored. Judge Cole reviewed the mediated settlement agreement from the bench. Her voice was procedural and unhurried. "The court finds the settlement terms fair and consistent with Georgia law. The prenuptial agreement is enforceable as written. The Beaumont Family Trust remains separate property as defined by both the agreement and applicable statute. Marital assets shall be divided as stipulated. Attorney's fees are allocated as agreed." She looked up briefly. "This matter is concluded." No gavel, just a clerk standing to collect the paperwork. Marcus exhaled. Beside him, Sandra gathered her folders with the careful efficiency of a woman who had closed many rooms like this. "It's done," she said quietly. "You have a clean start from here." He nodded. He was already thinking about the development project he'd put on hold months ago. A mixed-use residential conversion on the west side, a project he'd been working toward for 2 years. Something built from nothing, the way he'd always described what he loved. That was still his. That had always been his. And 3 weeks later, Celeste stood in her home office at 9 in the evening, the Atlanta skyline dark and glittering beyond the glass. Marcus's belongings had been moved out cleanly and without conflict. The apartment felt larger but not lonelier. It returned to itself, the way places do when they stop accommodating someone who was never entirely part of them. She opened her black notebook one last time. She turned through the pages slowly, not reading, just moving through the record. We're on October 4th through the final order. Dozens of entries. None of them emotional, none of them editorial, all of them exact. She found the last blank page and wrote, "Final order entered, classification affirmed, matter concluded, record closed." She put the pen down and sat for a long moment. Then she placed the notebook in the lower drawer of her desk, locked it, and turned off the lamp. Across the city, Marcus sat in his new apartment, a clean, modern space that was entirely, unambiguously his, and opened his laptop to the development project files he hadn't touched since August. The West Side conversion, 12 units, ground floor commercial, rooftop terrace. He had the land under contract. He had a contractor he trusted. He was realizing, more than he'd thought he had when he'd started this whole process, convinced that someone else's wealth was the answer to something he couldn't quite name. He stared at the project files for a long time. Then he opened a new document and started writing notes. Building from nothing. That had always been his thing. Maybe it still was. There are people who mistake silence for surrender and call it wisdom. There are people who look at the absence of a name on a document and see emptiness, when what they're actually seeing is the trace left by someone who understood that the most durable things are the ones you build in structure, not in spectacle. Celeste Beaumont had not won this case. When winning implies a contest, and she had never understood it that way. What she had done was maintain a trust built by a grandmother who had survived enough history to know that paper names are fragile, that systems outlast individuals, that the greatest protection against disruption is to never have allowed disruption a foothold in the first place. Marcus Whitfield had filed expecting half. What he received was definition, and definition, once rendered by a court, does not negotiate. But here is what neither attorney said in any brief, and what Judge Cole never put in any order. The real loss was not financial. Marcus had lost the story he'd been telling himself, the story about a fortress built against him, about a wife who had structured her world to exclude the people she let in. It had been a narrative, and narratives feel true when they serve a purpose. What the record revealed, the emails, the audio, the LLC formed 3 months before filing, was that the fortress he'd spent months trying to breach had never had his name on it because it had been built long before his name existed in her life. That wasn't exclusion. That was continuity. And continuity, when it stretches back far enough, doesn't look like a wall. It looks like a foundation. Celeste walked along the Beltline one Saturday morning in late February, Atlanta warming at the edges of winter the way it does. Gradually, then suddenly, she wore a gray tracksuit and her hair natural and loose, a coffee cup in her hand and her phone in her pocket without earbuds. She had learned to value silence as a practice rather than just a posture. She passed a young woman seated on a bench with a laptop open, typing rapidly, expression focused. The woman wore the look of someone building something, and Celeste recognized it. She'd worn it for years, sat board tables and conference calls and quiet evenings over governance documents. She didn't stop, but she smiled to herself. Her grandmother had once told her that the hardest thing about having power is that people spend so much time looking for it in the wrong places. They look at names, Dorothy Beaumont had said. They look at titles and deeds and what's written in whose column. But power isn't in a name. Power is in what continues when your name isn't there. The Beaumont Family Trust would continue. The holding companies would continue. The healthcare infrastructure would continue. The philanthropic foundations would continue. Celeste Beaumont would continue. She finished her coffee and walked home through the warming morning, unhurried, unannounced, unnamed on any document that mattered, exactly as designed.